Ross was found a few minutes after the robbery took place at one of the businesses nearby. He was found in
I'm correct. Court does, yes, court does call the cases. People of the state of Michigan versus Virgil James Ross.
We're ready on this matter, Sheriff.
I'll keep it people.
All right.
Round damage. Defender paying Whitman on behalf of Mr. Richard Ross. Mr. Ross, please take it over.
Virgil James Ross.
All right. Couple of things. First of all, this is your motion, Mr. Brown, starting the lineup.
Right. Okay. Thank you. Your Honor, we're here today for a motion for a live lineup in case 23 F55083FY. The motion is based on People versus McAllister and People versus Gwynn. The court has Mr. Ross before today. He's charged with the count of bank robbery in 5083. The allegations are that on May 11, 2023, Ann Arbor police were dispatched to Chase Bank on a reported robbery that had just occurred. There was no suspect present in the bank when the police arrived. So approximately 9 persons were present, none of whom could provide the direction in which the suspect was alleged to have fled. There was a bank security guard, Damon Weeks, who stated his view was obstructed, but described the suspect as a black male with a hood on. And that's cited in the brief there, where you can see that on the body cam. There's a bank teller, Lynn Sleva, who says that she had the best view of the suspect. She stated the suspect was wearing white, had on a white hat, and she could see braids in his hair. That's also in the video at between 1:55 and 2 minutes. Now, there's also a Cynthia Chalkley. She's a teller who allegedly, she was a teller who was allegedly robbed, and she described the suspect as a black male with black hair. That's all that's in the police report. Ms. Sleva stated that she saw the suspect best and was asked to do an in-person identification of the suspect while he was in custody. So Ms. Sleva was accompanied by police, the Ann Arbor police, to a vehicle in which Mr. Virgil Ross was seated. Ms. Sleva told police that the person in the police vehicle was not the suspect. And this is after she had a chance to look right at Mr. Ross sitting in that vehicle. Now, McAllister sets forth that a right to a lineup arises when eyewitness identification has been shown to be a material issue and when there's a reasonable likelihood of mistaken identification that a lineup would tend to resolve. Let's get a little deeper in that if we could. Now, McAllister, as I said, sets forth the right to a lineup when eyewitness identification has been shown to be a material issue. That's the first prong. And the second prong is where a reasonable likelihood of mistaken identification that a lineup would tend to resolve. In this particular case, the eyewitness identification is a material issue because statements made by purported eyewitnesses do not describe Mr. Ross. Where witnesses stated the suspect had braids, Mr. Ross has a shaven head and a large beard. No eyewitness described a man with a beard. Ms. Sleva told police that the suspect did not have a beard when she saw Mr. Ross. And Mr. Ross, at the time he was sitting in the police vehicle, did in fact have a beard. There's a reasonable likelihood of mistaken identification because Ms. Sleva told police that Mr. Ross was not the suspect. Ms. Sleva stated she saw the suspect best. She was the only person to do an in-person identification on the day of the alleged incident. Still, Ms. Sleva told police that Mr. Ross was not the suspect. We believe a lineup would tend to resolve these issues because Ms. Sleva, again, was the only witness asked to make an in-person identification on the day of the alleged incident. Mr. Weeks and Ms. Shockley were both present in the lobby at the time of the alleged incident and gave descriptions consistent with Ms. Sleeva's description. However, Ms. Sleeva told police that Mr. Ross was not the suspect, and Mr. Weeks and Ms. Shockley were not asked to make an in-person identification. Court has the discretion to determine whether an in-person lineup is necessary. An in-person lineup is necessary in this case because neither Damon Weeks or Cynthia Shockley nor Cynthia Slivia have identified Virgil Ross as the suspect they described.
Thank you. Response.
Thank you, Your Honor.
In this case, well, first of all, Judge, I don't know if there's an objection, but I'd like to supplement Mr. Danner's response with 2 photographs that were taken from the videos. Can I approach?
Yeah. Thank you.
McAllister requires, or McAllister suggests that a lineup may be appropriate in a situation where it could resolve any, quote, mistaken identification. In this case, as Mr. Danner pointed out, there really isn't any. And that's due to the good old-fashioned police work of the Ann Arbor Police Department when they investigated this case. Mr. Ross was found a few minutes after the robbery took place at one of the businesses nearby. He was found inside that business wearing a t-shirt, a white tracksuit, orange shoes. The t-shirt, and which also met the description of the individual who committed the bank robbery. He was found with a large quantity of money in new crispy bills, and in various denominations that actually Mr. Danner didn't point out, but they do match quite closely the denominations that were reported to have been stolen. He was found with what was described as a COVID mask and white or clear see-through gloves, or clear rubber gloves that were described by witnesses as being worn by the person who committed this robbery. On the way towards the store where he was found, which was Moose Jaw, there was a Starbucks, which he had told police that he was just inside. Right outside the Starbucks, in the trash can, there were handwritten notes demanding money, essentially the note that was passed to the bank teller, demanding money, no buy packs, if you want to get home. There was an additional item that was found with Mr. Ross, which was a small notebook that had some personal items in it. And also on some of the pages, there appeared to be sort of what attempts might have been made towards a bank robbery note of $5,000 and $100 bills, no die packs. This was all developed by the Ann Arbor Police Department after they arrived at the Chase Bank and started talking to witnesses. One of the things in the photos you'll see that I've submitted as People's Exhibit 1 for today's purposes is a photo of a screenshot of the robbery as it was taking place. You'll notice that the individual is wearing something about his head. It appears to be a scarf that wraps his head and face, and he's also wearing a what would be described as a surgical mask. So there's that. One thing that's very descriptive and is an example of the type of police work and what I described as good old-fashioned police work of listening to a description, talking to various witnesses, and then putting it together when the police made their identification of Mr. Ross as the bank robber can actually be seen in the photos that I submitted. If you look at, it's a little easier to see in number 2, but you'll see it in number 1 as well. Mr. Ross, when he was arrested, was wearing an inside-out beige t-shirt. The image on what would have been the normal outside of that shirt is bleeding through and can be seen. That same image can be seen in the photo of the person robbing the bank. that's the example, an example of why, what Mr. Danner was getting at in his response, as to why a lineup is unnecessary. And in this case, there is no mistaken identification. The police did their job. The police tracked down and identified the suspect with this, and subjecting the witnesses to a lineup is unnecessary in this case. One of the things that Gwynn, which McAllister cited, that the court ought to suggested the court should consider is that the court should look at, in addition to whether or not it would resolve anything, but the burden to the witnesses in doing so when weighed with. So, thank you.
Anything additional, Mr. Brown?
Yes, thank you. So the prosecution points to a picture. One of the things that has not been cited or stated is Mr. Ross had been in that bank earlier, and gotten changed, gotten singles. Problem is, we don't know what that picture depicts, when it depicts, or what's supposed to have happened. And that's a problem. But more importantly, Mr. Ross isn't charged with having items which may have been involved with a robbery. He's charged with actually committing a bank robbery. What the police are basing their information on is not the identification. And we have a misidentification. We have a person who was there and says, that's not the person who did it. They're looking in the car, looking directly at Mr. Ross, saying, that's not the person who did it. When the prosecution says, well, we've got identification because this person had all of these items, and we have a picture of this person being in the bank. Well, when you put together the fact that Mr. Ross was in the bank earlier in the day and got changed, and the fact that for the police to even begin to try to pick up a suspect, they have to rely on an identification. They have to rely on what someone told them this person looked like. And based on that information, they go and do whatever research it is they're doing, and they pick up a person. Then they're told by the witness who saw the person commit the robbery, that's not the person. Then you have an identification issue. You have a problem with the identification because the police weren't there. They have to rely on what they're told. They have to rely on what's been said to them, how that person's been described. And when those people who have given the description say, sorry, that's not the guy, then you have an identification, have a controversy as to that identification.
Can I just, who are you asking to view this lineup?
The people who were in the bank, the people who were actually there, the security guard who says the person they saw had braids.
Okay.
The other teller who's there, who describes him as having no beard. And Mr. Ross, at the time he was picked up, had a full beard. I think fairness and justice demands that he be allowed to have an identification or eyewitness, a lineup, an in-person lineup, to make sure that they have not picked up the wrong person. Because remember, even if these items can be associated with the bank robbery, those items are fungible. That is inherent in those items that is attached to the person who committed the robbery. In other words, the items that they found on Mr. Ross could have been discarded by the person who actually committed the bank robbery. And if Mr. Ross picks those up, that still doesn't make him guilty of committing a bank robbery. That doesn't even put him in the bank.
But your proposition isn't that the people are relying upon an identification. Is that right? I mean, you're not arguing that the people are relying upon this identification to say who the robber was.
They are, in fact. That's why they developed Mr. Ross, the individual they find in the store, as a suspect. That's why they say he's the guy. But remember,
I thought it was something. I thought it was not the recognition of the person, as opposed to maybe what the person was wearing, that led police in that direction.
and so they were told that the person had a white cap, that he had braids.
Well, what you said about what they were wearing, like the white and the like,
Yeah, there's certainly nothing unique about wearing a white shirt.
No, there isn't, but I guess because normally this is somewhat a little bit backward from what we normally end up with, is what I'm saying, and I'm trying to logic it through in my head.
Okay.
Because what brings the, again, I don't have the police report, but what it seems brings the police into contact is other identifying things that they receive from people that then bring them into contact with him.
Certainly not anyone who was in the bank who was an eyewitness to the alleged robbery. They have one person who says, "Hey, you're looking for a guy who looks squirrely. He's going to different doors." And that's how they end up going into the moose shop, because some person standing out on the street who was not an eyewitness to any bank robbery decides that Mr. Ross looks suspicious. And we can guess on what they base that.
So you're looking for the identification for the purposes that these people cannot say that it was your client.
They're saying specifically it was somebody else. They're just not saying, "Oh, well, could be him, could not be him. We're not sure." They're saying there was someone else who did. That's what they're saying when they say the person had no beard. Because they're saying when they say the person had either braids or hair. At the time, Mr. Ross was bald-headed, as he is now.
Right, but I guess a little bit. Okay. I think I get the argument. Like I said, it's just a little bit backwards from what one is accustomed to seeing, but okay. Anything else?
No, Your Honor. We would ask that the court grant our motion for a live lineup, because the eyewitnesses themselves have pretty much said that this is not the guy who did it.
When you said that, that reminds me, but the people's evidence isn't them saying it is him. Is it?
Well, that would be why he's here, I suppose.
Well, no, I mean, the reason he's here, I'm presuming, is, at least as I hear the people's argument, is because of what he was attired in and what they knew from the photos in the bank. And you may have your justification for him being in the bank. I get that. But that's why he's here. And maybe the person that you say there's somebody running in and out, running squirrely, okay. So that they follow that. But that's why I think he's here. There isn't somebody, as I'm hearing it, there isn't somebody that from the bank, from the scene, that is saying this is him.
That's true. There is not someone from the bank who's saying. In fact, we believe there are people who will say that is not him.
Okay, and that's where I get a little bit of my confusion. So then why would I have a lineup? Well, let me put it this way. Why would defense be requesting a lineup where I know that people are going to say that's not him, or I don't know who that is?
Because we believe that his sitting at that table is going to change that. And we don't want them to be able to come and say, "Oh, yeah, that's it. Oh, sure. Now
I see. I see. Okay. That's what you're trying to protect. I see. I get it now. If you just told me that, then we could have cut all of this out. Well, I was just trying to figure. All right. Anything else from the people?
Judge, I think you had it right where the people are relying on
What essentially I would say the corroborating evidence to establish the robber and Mr. Ross's identification. It's not that someone from the bank, we're expecting anyone from the bank to come in and say, that's the guy, or to look at him, because.
But I guess it isn't the danger that they all of a sudden get in a proceeding and all of a sudden then say that is the guy. And there should have maybe been an identification beforehand. I guess one thing I'd ask, so from the people's standpoint, is they eventually have Mr. Ross in custody, at least to the point that they can bring one of the people down to attempt to identify Mr. Ross, right?
And they did.
And they said it wasn't him, or that doesn't look like the person. So why didn't they bring everybody down?
I don't have that answer. I don't know.
Just good old fashioned police work. Because that's what I don't understand, because I think that had that occurred, I'm probably not here hearing this motion.
So what I can tell you though, Judge, is that in reviewing the file, on the way back to the bank with Ms. Silva, the officer who's walking with her, gets the video from the bank, which that first shot that I gave you is from. Ms.
Okay.
Silva was saying she thought, as I recall, she thought he had a white hat on or something. Well, clearly he's not wearing a white hat. He's got white about his head in the form of the mask, but he's not wearing a white hat.
Right.
So, I mean, essentially it's a thing of, as much as someone might be saying mistaken identification, the people are here and we will have to deal with what Ms. Silva said on the side of the road when they tried to do the show up. But what they had done before, in addition to trying to take Ms. Sleeve it down, they had developed this other information. $1,600 bills were stolen. $1,600 bills were found in his pockets. A total of approximately a little more than $2,600 was stolen. A little more than $2,600 was in his pockets. He had the orange shoes, which were distinctive, the white pants, which were distinctive. The shirt, which was somewhat distinctive. Although it was inside out, he was still wearing it inside out when he was found. The person outside of the Starbucks who said, he went into Moose Jaw. I mean, it was the same as if somebody was just, said, hey, I saw the guy running down the street and he went over there. That's how they found this. That's how they located him.
What's the harm from the people in just having the lineup?
The harm to the people?
Yeah, I mean, why oppose it? In a circumstance such as this one?
Sure. I would say, potentially re-traumatizing the victim who was robbed, who it took a few moments to figure out that she was surprised that this was happening to her through the form of a lineup and having to go through all this.
Traumatizing than the preliminary examination or trial itself?
Additional.
Maybe. Okay. I mean, but that's the only reason?
Well, the other thing is, I can see this as a tactic to just start inserting, trying to create reasonable doubt at this point. If the witnesses come and say, I can't say, that we're still in the same place.
Well, you may be in the same place, but you guys might be in the same place. I don't know that defense is in the same place.
Sure.
Because from the defendant standpoint, and it was the last thing that Mr. Brown said, what's going to happen is somebody, I'm presuming, is going to get on the stand, either at preliminary examination or at trial, and they're going to say, do you see that person in the courtroom? And they're going to point at it. And there's nothing that checks that in this particular type of case, because had they taken all 4 or 5 people down there, I don't think that argument holds much weight, because now everybody has given their whatever statement they have, right?
Right. However,
But we don't have that.
correct. But then you have a different issue, potentially, where he's in the bank about an hour beforehand. And now it's an identification based on just seeing somebody very recently. And now.
Oh, absolutely. But you're always going to have that.
Sure. But you're always going to have the ability to cross-examine and say, look, you told the police you couldn't tell who it was.
Well, yeah,
What?
I know it's true, but I mean, I think the point is, especially if there's going to be a preliminary examination, some of these witnesses are going to come in. They're going to look over there. That's going to be what attaches. Potentially. I think more likely than not. And then it's going to get later down the line at trial, but now that face is fixed.
Thank you.
I don't know that I need any additional argument. I mean, I wasn't following initially at first the defendant's argument regarding why they would want to light up. It was a bit confusing as to why they might in this case. When I think about the circumstances here, in this case is, I won't say it was unique because I haven't seen every case in the world, right? But it seems to me that it's a circumstance where a lineup may indeed be justified in this instance. I think it had the police gone, and if they had identified this individual as a suspect, and then anyone that may have gotten a glimpse of him, they go and do the show up at that point. I don't think we have this issue, but they bring one person down. They say it's not him, but I mean, there's always the danger. And it's a bell that you can't unring. That once they get in here, somebody who said something sort of innocuous in the police report, all of a sudden is now absolutely sure that this is the individual. And I think there's a huge danger at this point. So I'm going to order that a lineup be conducted in this case. Mr. Brown, you will prepare the order.
Thank you, Your Honor. We will prepare.
And that's for the witnesses that Mr. Brown was citing in his motion.
Yes, for the individuals that were present in the bank that gave, I guess, really any description of that person, because those are the ones that really are going to potentially be problematic. All right, so I'll grant the motion. We have one other issue, and I got a full courtroom here waiting, but on the 9th, I think defendant was here on the 15th, if I'm not mistaken. On the 9th, but not received by the court, I don't think at that time, he sent a communication into the court requesting, I think, kind of the stuff he was trying to tell me the last time that we were here. I'm going to take it neither side has seen that. Have you seen it, Mr. Brown?
Same thing I said today.
I've certainly heard of it, Your Honor. I don't think I've seen it, but I have heard of it. Obviously.
I can secure that by sending me.
What?
I can speak. They did send. I got what I asked for. Majority of what I asked for 3 days ago.
Here's a quick question. Would you like to withdraw?
Yes.
You want to withdraw the motion claiming ineffective assistant counsel of the person that just won that motion?
Yes.
What a concept. All right, I'll consider the motion withdrawn. Thank you. We do have to give another date on that. We'll put them both over to July 6th. Why not Feaster Day? Oh, that's great. And why don't we, I don't want those in, yeah, to the prosecutor, because I don't want those in the file. Pardon?
That be a PD date or
Probable cause. And I don't, I'm gonna put it over to the 6th. Counsel can by stipulation.
This case was not a sovereign citizen case. Instead, it centered on one of the most important issues in criminal law, the reliability of eyewitness identification. The defense argued that the physical descriptions given by witnesses did not match the defendant. One witness even looked directly at him shortly after the robbery and reportedly told police he was not the robber. Because identity was genuinely disputed, the defense requested a live lineup so multiple witnesses could make an identification under controlled conditions. The prosecution responded that its case did not primarily depend on eyewitness testimony. Instead, it relied on circumstantial and physical evidence, including clothing, cash, surveillance images, and items allegedly connected to the robbery. The judge recognized that evidence, but also acknowledged the risk that, without a formal lineup, later courtroom identifications could become more persuasive, simply because witnesses repeatedly saw the defendant sitting at the defense table. Ultimately, the judge granted the request for a live lineup, emphasizing fairness and the integrity of the identification process. The ruling demonstrates an important legal principle. When identity is a genuine issue, courts may require additional safeguards to reduce the risk of mistaken identification. Cases like this highlight why criminal trials depend not only on evidence pointing toward guilt, but also on procedures designed to ensure that evidence is tested fairly before a verdict is reached.